All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. One more time. We are here in Wednesday, CV130703, Arizona Biltmore versus Arizona Biltmore Master Association. Each side will have 20 minutes to present their argument. Apparently, you may reserve any portion of that you want for rebuttal, but it's up to you to watch your time. We are recording the argument today by video and audio. The argument will be on YouTube in a day or two. We have read the briefs and conference of case, so we are familiar with the facts and circumstances. So please just launch right into your argument. Counsel, you may begin.
If it please the court, I am Steve Tully, appearing on behalf of the Arizona Biltmore, Hotel Villas Condominium Association, and I'm joined here today by Rich Barr, its president. This is an appeal of a dismissal of a declaratory relief action filed by the Villa Association. The Villa Association filed a declaratory relief action asking the court to determine its rights pursuant to several contracts, including a couple land use declarations. The court, and that's all it asked for, and the court below declined to rule on that action, held that the matter was moot, and awarded the appellees their attorney's fees and dismissed the matter. The court below erred. The matter is and was not moot. Pursuant to Arizona ARS 12-1832, any person interested under a deed, a will, a written contract, or other writing may have determined any question of construction or validity under that contract or written document and obtain a declaration of rights, status, or other legal obligations thereunder. So any person who has a contract and have his rights determined under that. That's what the statute says. That's what was asked for in this case.
Yeah, because does that matter if the joint use agreement provides something else and takes precedence over that, or do I not understand the fact?
Sure, well,
as I understand it, it's a joint use agreement now, correct?
There's sort of two issues, Your Honor. The first issue, the declaratory action asks that the court declare the sort of writ of the CC&Rs, right? Whether they controlled this 50 feet north of the canal. And the second issue was whether or not then, depending on the determination of that, whether this joint use agreement, whether there was any rights by the Master Association into that joint use agreement. Now, whether or not the joint use agreement is currently valid or not, the court certainly is able to determine the rights of the parties and declare the rights of parties pursuant to that agreement, because the Declaratory Judgment Act says that specifically. It says the court has the right to determine the rights even after a breach of a contract.
Well, this isn't a breach, though, right? This is a cancellation. I mean, what active instrument does your client have an interest in?
Well, it has an interest in two instruments. Two instruments. It has an interest in the Declaration of Rights, both the Villa's Declaration of Rights and the Declaration of Rights of the Master Association, and their writ as far as how far what property they're covered. So that's one issue in the declaratory action. We asked that that be declared, the rights of the parties be declared as to those two things. That was never ruled on by the court. That's still live. There's no reason why that can't be ruled on. The second issue was whether or not pursuant, and it really wasn't interpreting the joint use agreement technically, it wasn't really asked. It was whether or not, given the determination of the first issue, whether or not the master association could claim any rights if it didn't control the property over the contract, the joint use agreement between the Salt River Project and the Villa Association. And the response was this after acquired claim that, well, they should have acquired the rights afterwards. So it really wasn't asking the court below or here to sort of interpret the terms of the joint use agreement. It said, determine the rights of the parties pursuant to that. Can you do it now? Sure. You can determine. That matter is, there's currently a litigation going on between SRP and the Villa Association regarding the breach of that contract and whether or not, in the rights regarding that contract, whether, determined by the court will have an impact on, can have an impact on whether or not there are damages in that action. And so, I mean, it's certainly, the court certainly has the power to determine whether or not, if the CC&Rs don't cover that property, whether or not the Master Association has any claim on the rights granted in the joint use agreement. And so, I mean, ARS 12-1831, courts of record within their respective jurisdictions shall have the power to declare rights, status, and other legal relations, whether or not further relief is or could be claimed. So, I mean, whether or not you can enforce any rights pursuant to that joint use agreement is not required for declaratory relief action. You can't moot the claim by going around and taking actions to defeat the contract.
Well, can you identify any practical remedy that could result from continuation of a declaratory judgment action at this point? Is it purely academic?
Well, no. First off, I want to do this. First off, again, I want to reiterate: we don't need to have any. Whether any, the court, the statute's clear. You don't have to. There can be no relief available to my client, and we can still ask the court to declare the party's rights pursuant to the contracts. That's what.
I'm asking you a different question.
Right.
Is there any relief available to your client?
Well, yes. I mean, there's another suit going on, so there's some relief there. But here's I'd like to pose another issue. My client has the right to know what control, whether its property line is here or there, whether the CCRs control a piece of the property or not, regardless of the SRP joint use agreement. They have a right to ask the court to say, there's two agreements here. We want to know which one governs and whether they govern that piece of property.
But at bottom, your client wants some parking spaces, right?
At bottom, my client would like some of the revenue that is gotten from the parking spaces. That is one of the requirements. But there's a huge difference between asking a court for relief and asking the court to declare the rights that someone might have. And that's why we have a declaratory action. Otherwise, there would be no purpose for the declaratory action. We just have an injunction, right? And that's really the argument they're saying. They're saying, well, yeah, you asked for an injunction, and you can't get an injunction, so your case is dismissed as moot. That's not the law. The law is, I didn't ask for an injunction. We specifically didn't ask for an injunction because we didn't want to enjoin them. We want them to use the parking lot. So what we asked for is, we asked the court to declare our rights pursuant to these contracts, and there is nothing in the law that allows the court to say, yeah, but you know what? Really think you wanted an injunction. I mean, you really wanted an injunction. You really wanted to get the cost. So what we're going to do is we're going to rewrite your complaint. We're going to call it a claim for injunctive relief and dismiss it. No, we asked for declaratory relief only.
And I mean, I'm still struggling to see why you would do that. You either wanted the spaces or you wanted the revenue.
Your Honor, the reason we wanted to do it is because there was a dispute among the parties about the control of the parking lot. Now, if we had a right to it, the relatively easiest, cheapest, inexpensive way of determining the rights of the parties was to go to the court and say we could sit around and write letters to each other, but that wasn't getting anywhere. Is to ask the court, declare our rights, Your Honor, tell us who owns it. And then, once we knew that, we could decide whether there was any value in litigating what they might be worth and what we're entitled to or not. We just said, tell us our rights. That's why we did it that way. We didn't want to have World War III. We wanted the least expensive. I represent a villa association. It's not a big bucks corporation. And they just said, look, there's these two titles to property out there. They're inconsistent with each other. Under one, it looks like we have the right to control that parking lot, in which case there's revenue generated by that. Under the other, we probably don't. Court, just tell us who owns it. Tell us who owns it, and then we'll figure out later whether we want any additional relief. And that's precisely what the Declaratory Judgment Act says we have a right to do. That's what that's what we asked. And there's absolutely nothing moot by the fact that the SRP, that actually the appellants were able to manufacture a set of facts that caused SRP to terminate that contract. There's nothing about that fact that rendered the court unable to declare our rights pursuant to the contract. Absolutely nothing. And they've cited no case law that suggests that.
Okay. Let me ask it slightly differently. Would you agree that the SRP has granted a license to the Master Development Association to use the part of the lot in question?
Currently now, they had, I think at the time that we argued the motion the motion, their amended motion for summary judgment, my motion for summary judgment, they had some type of license. Now, since that time, I think it was a temporary license. They were going to have a permanent agreement. I can't say, right now what the current status is because I'm not handling that other case. But I assume that's true, but I can't tell you for certain.
Well, let's assume together then for a moment that it's true.
Okay.
That there is a right to use that land. If we agree that there is a right, does it matter under which document there is that right?
Yes. Oh, sure.
And why is that?
Because the document may be worthless. If the document granting the right is issued by the U.S. government and the U.S. government doesn't own the property, it's an easement, then it's a worthless piece of document. It's a worthless document that grants no rights. If, on the other hand, the flood control district owns the property, then if the flood control doesn't own the property and the U.S. government does, then the easement granted by the flood control district, for which, by the way, the Villa Association pays an annual fee, which now currently includes that property, is worthless, and is now worthless, but is attempting to control property that it doesn't control. Only one can control the property, and so we're asking the court just to declare that issue. Tell us which one controls the property. And it does matter, and it doesn't even have to matter on a practical basis, but it does. But it doesn't have to for the court to declare the rights of the parties pursuant to that agreement. And so, so the matter is not moot. The court had the power to decide, it just didn't want to. And actually, in a way, it decided for the Villa Association because initially the court, the Villa Association asked the court to declare that the U.S. government owned the property and therefore that and that's all it said. It determined that the U.S. government controls the property and therefore the Villa Association's declaration and the Master Association declaration can't control that 50 feet piece of property because you can't put a CC&R over property that you don't own. That's Arizona law, state law. The Villa Association, or at that time, the hotel's position and the Master Association's position was no, they just have an easement. Well, by the time they cut an agreement with the U.S. government. They've changed their position, and then they filed this new motion with the court in which they conceded the U.S. government owned it. And in fact, if you look at the order from the court below, the minute entry from the court below, the court states that the U.S. government owns the property. And it says the parties concede that, and in fact, in page 6 of their response brief, they concede that the U.S. government owns the property. So what does that mean? That means if the U.S. government owns the property, then the court can and should declare that the two declarations that attempt to control that property, that 50 feet, don't. Right. So that's all been admitted. So the court agreed with that. That was what we asked for. Basically, the court below agreed with that, but then they didn't follow through. It declared the case was moot and actually and dismissed it. Well, that was an error. And so what we'd ask the court to do now is to declare, in fact, what everybody seems to agree to, which is the only thing we asked for in the first place, that the U.S. government owns the property. The declarations don't control that piece of property. And that's a finding for the Villa Association. The second issue that was asked was below. The other thing was to declare that there was no rights of the Master Association into the benefits of the joint use agreement with SRP. And the response to that was that they had after acquired rights. That's all been argued below in the motions, the cross motions for summary judgment. They withdrew the issue about who owned the property, but they claimed that they obtained the rights to the joint use agreement through an after acquired. We don't think that argument holds water. We don't think it's a proper statement of the after acquired property rights. So the reason I mention that is that now what we have is we have a case that was dismissed because it was moot. It was not moot. It's not moot under the statute. It's not moot under Arizona law. And so, but we have a findings from the court that are consistent with granting relief to the Villa Association. So we'd ask that this panel obviously reverse the decision of the court below, but also grant us the relief we requested in the declaratory action. Grant us, declare the rights as now appear to be generally admitted, and award us our attorney's fees and costs incurred in this matter. And I'll reserve the last 4 minutes of my time and answer any questions that you may have.
Thank you, counsel.
Thank you.
May it please the court, Kevin Parker for Appellees. I'll be arguing for both the hotel and the Master Association. First, to address a couple issues that came up in Pellant's argument. He mentioned that there's an injunction request. Nobody interpreted their claim as an injunction request. Everyone interpreted it, including the judge and us, as a request for a declaratory relief to declare certain rights. So that's just a red herring. Judge Schwan asked, do we have a license? We do have a license now. At the time of the order, there was a temporary but an agreement to issue. That's in the public record. It's recording 2013-034-0346. With respect to the suggestion that the court should declare who is the owner of the property as between the United States and Maricopa County Flood Control District, we conceded for the purposes of the motion, because their arguments were moot, that let's assume for the purposes of the motion the United States owns it. We agreed to support the United States if and when the decision is ever made as between the United States and Maricopa County Flood Control District. But this is a great example of why a declaratory judgment, you don't get the relief you ask for in a declaratory judgment action just because you ask for it. There is a whole separate layer of rules that prevent parties from just overburdening the court with hypothetical moot declaratory judgment requests. As in this case, they want a declaration of ownership. One of the rules is you need the interested parties present, of course, before you can declare who owns a property. They joined in neither the county flood control district or the United States, which required us to go to federal court to join them. They want a declaration on the joint use agreement. It doesn't exist. The courts don't answer such moot questions. And, by the way, they did not even join SRP in this case. SRP is the other party to the joint use agreement before it was terminated. So what they've asked for in their brief is let's just go ahead and get a declaration, even though it doesn't exist. Give us a declaration of rights under the joint use agreement, because we want to go over to the other case where we're suing SRP and use that against SRP in that case. That's another reason the courts don't enter declaratory judgments in such circumstances. That's just wrong. SRP's not in this case. This court should not make a declaration that, and this is where they state it, is their opening brief, page 10. Here's why we want it. We got another case against SRP. We prefer that this court, without SRP being around, grant us some rights in this agreement so we can use it as part of our damage claim against SRP.
Can the issue be litigated in the other action?
Absolutely. I mean, I think that's their point, is they don't want to go to the other action to do it. They would prefer to do it here. But absolutely, they even state this is an element of our damage claim against SRP, a declaration of rights under this joint use agreement, which of course doesn't exist anymore. So that's another screening tool for the court to weed out declaratory judgments that are moot, advisory, hypothetical, or inappropriate for any other reason. So what they're essentially asking for is a declaratory judgment on two issues that are moot, and they want to avoid the judgment on the issue that was the real issue. The real issue was that, and they say this over and over and over, and we've quoted it in our brief, the real issue is they want a declaration that they control this parking lot. Their chain of argument is USA owns it, the declarations don't apply, so the joint use agreement is the operative document. You have no license, so we can exclude you from the parking lot. All of those fail. Number one fails, United States isn't even a party. Number two fails, keep in mind what CC&Rs are, the declarations. They're attempts to impose restrictions on the owner's property. They don't even have the owner in the case, and they want this court to decide what restrictions burden that property. Step 3 is the joint use agreement does not exist. The other party to the agreement is not even here. So what the court could rule on, and the court did rule on, is their ultimate claim for relief, which they stated over and over and over. This is our chain of logic. We want this court to declare that we control this parking lot and we can exclude the master association. The trial court properly rejected that argument, because one element of the argument is moot. The joint use agreement, and we want a favorable interpretation under the joint use agreement, that's an element of their claim. That doesn't exist anymore. That's moot. But because of that failure, it's a failure for two reasons. It's a failure on that point, but it's also a fundamental failure on their claim as a whole. Their claim is on the whole is we want an order allowing us, declaring that we control this parking lot and we can exclude the master association and the hotel. That claim was properly dismissed with prejudice. The court, pursuant to all of the fundamental rules, the complaint just starts the process. Rule 15B, the pleadings are deemed amended to conform to the evidence. 54D, the court is to grant the party in whose favor the court grants the relief what relief they are entitled to. Under 54, they say, well, Judge, you didn't grant the relief we wanted and you're limited to that. No, the court grants the relief, the court granted the relief that we wanted. We're a party to this case too. We won. Rule 54D says grant the relief to which the party is entitled, all the relief that they're entitled to, whether it's in the pleadings or not. Our request for relief on summary judgment was to dismiss their claim with prejudice. That's the only relief that was appropriate in the case. That's the relief that was granted. The suggestion that even though the joint use agreement is gone, that the court should go ahead and make a declaratory judgment as to the scope of the CC&Rs, I addressed that briefly, that again, the parties that own the property that they're seeking to either impose or not impose these CC&Rs on, those parties aren't even here. If they want to file, and that's why we had to file a case in federal court, because they didn't join SRP, they didn't join the United States, which has to be sued in federal court, and they didn't join Maricopa County Flood Control District. So we had to go to federal court to get all the parties in play. We settled that case with the United States by, remember, the base we already had covered no question, was through the Maricopa County Flood Control chain of title. That chain of title, Flood Control District has the deed. If you look at the property records, they have the deed. We have an easement from them. What the debate was, well, what if the United States owns it? What do you have from them? Their argument was, we have the joint use agreement, you have nothing. It's gone. The settlement with the United States was, we agree to support them in whatever fight they may have down the road on ownership in return for a 100-year license. We have a 100-year license. We have both bases covered. We have the county ownership base covered. If in some future lawsuit between the United States and the county wins, we have the United States line of title base covered through our 100-year license. It's appropriate for the dismissal with prejudice. And I'd, of course, be happy to answer any questions.
No. Thank you, counsel. Mr. Tully?
I think if you please the court, I mean, there's a lot of talk there about issues that are completely irrelevant to this action. This is a very clear-cut question on appeal. Was the case moot? And was it, because that's what it was dismissed on. It was dismissed as moot. Was the...
I'm more concerned with whether it's justiciable, and it does seem that it's difficult to identify rights that can be declared in this action without affecting the rights of parties who haven't been joined or couldn't be joined to this action.
And I'd love to address that, and I've only got a short period of time. First off, the idea that they had to file a quiet title action in federal court in this case is a canard. It's not true at all. They decided to take that action. It was not required. Nothing under the rules, no statute required them to do so.
The United States may own the land, right?
May own the land.
And if the United States may own the land and it can't be sued here,
but we didn't ask for a determination of our rights as against the United States. We asked for a determination of the contractual rights as against the Master Association only. The Master Association has some contractual rights pursuant to these deeds. We had some contractual rights. We said court determined those contractual rights. We specifically didn't want to add everybody everybody under the sun, make this into a huge action by including the U.S. government. If they thought that they were necessary parties, they should have made a motion below to add them.
You can't make a motion in state court to join the United States as an indispensable party.
You can make a motion to dismiss the action for failure to join an indispensable party. They did none of that. They never brought it up. They filed a motion for summary judgment, which implicitly indicated that they believed everybody was there that needed to be there. They filed a cross motion for summary judgment. Said, Judge, decide this thing. They filed replies. The whole matter was briefed. And it was only after, and the court was about to decide the issue, that's when they filed their action in federal court. So that's never, and then none of those issues, by the way, have been briefed to this court. They've not been briefed below, and they didn't do any of that action which they could have done and should have done if they really believed what they were claiming today, that there wasn't the necessary parties. In fact,
are you just trying to find out whether your rights are superior to theirs without getting a determination as to who actually owns the property?
well, see now, originally.
Why would you do that?
Well, now because there's an admission by them that they agree that the U.S. government owns the property. So right now, we really don't need that. We just need a determination from the court that says that that based on that the parties can enforce the CC&Rs as against over the 50 feet north of the canal.
An admission by one side that the United States owns the property, though, is just that. It's an admission. It's not a determination.
But we're not asking for a determination that's going to quiet title anyone. We're asking
for a conditional declaration. If facts A, B, C are true, then here's the consequence. We're
asking for the court to declare that the Master Association can't enforce itself against the Villa Association over those 50 feet. It can't say that there's language that indicates in the declaration that they would control parking lots in the 50 feet for the benefit of the hotel, and we're saying that portion doesn't apply because you see the Villa Association had to get a separate contract with SRP for that property and granting it the exclusive rights to use those areas for parking spaces. And the master association says we have we control that pursuant to the master association, and therefore we get to use those parking spaces for the benefit of the hotel. And so this is all this thing was asking. Okay, there's that chain of title, and then there's this joint use agreement that says we control it. We control those 50 feet, and so we're just asking the court to determine the rights of the people pursuant to their contracts. Nothing else.
Thank you, counsel. Your time is up.
Thank you.
Thank you for your argument. We will issue a decision in due course. We stand adjourned. Thank you.